Okay, guys, welcome once again to another episode of Scott Talks Law. So, this is an episode whereby Scott talks law, and this particular episode shall be talking about hire purchase law, and we shall be looking at this hire purchase law under the unit of commercial law. So, we shall be looking at the definition of hire purchase law, how the Act of Hire Purchase applies in Kenya, how it was introduced, how it was enacted, the amendments, how it is being used in Kenya, and the view of various people concerning the Act during the time when it was being presented in the Kenyan Parliament. We have people like Masinde Muliro, we have people like who gave their own opinion about that particular act. We have people like Mati Shikuku. They have their own view about this hire purchase act. We're going to look at them, their own opinion about the act. We're also going to look at the elements of hire purchase and the obligations and parties to hire purchase, the case classicals of Helbis versus Matthew, the case classicals that forms the elements, establishes the elements on hire purchase, the contractual parties, the contract of parties, those elements of hire purchase. I'm going to look at all of them from that case classicals of Helbis versus Matthews. And we're going also to talk about relationship between hire purchase and other laws like bailment, the relationship between hire purchase and bailment, the relationship between hire purchase and sale of goods, and the relationship between hire purchase and credit pay. And you're also going to see that hire purchase involves payments in installments, but there is also a cash price that is supposed to be paid, though it is being paid in installments. So we're going to look at all of those things, but before going there, we need first of all to define what hire purchase is. So hire purchase is the agreement of bailments of goods where the bailee owes or gets possession after paying all the installments. So according to the Hire Purchase Act, it gives a definition that hire purchase agreement means an agreement for the bailment of goods under which the bailee may buy the goods, or under which the property goods will pass to the bailee, and where so this is the agreement for bailment of goods where the property will pass to the bailee. You know, under bailment, the property does not permanently pass to the bailee. Bailee just hold the goods temporarily, but under hire purchase, it's an agreement for bailment of goods where the goods will pass permanently to the bailee after that those final installments are paid. So the definition and nature of hire purchase. So hire purchase was enacted to bring sanity to the agreements by the virus of bargaining power. So it just came to bring sanity to the agreements by that variance of bargaining power. But without hire purchase, there was no bargaining power. You just need to pay goods in cash price. So when you pay goods or buy goods in cash price, you see that there's no bargaining power. So it just came to bring sanity to narrow the variance in bargaining power between the parties. Just came to give sanity to hire purchase agreement, that this hire purchase act. So the hire purchase act came to bring sanity to the hire purchase agreement. So presently in Kenya is governed by Hire Purchase Act Cap 507, which is mainly modeled on the English hire purchase law. So the UK Act was transplanted in Kenya between 1964 and 1958 to 1964. So it was amended twice in 1958 and 1964. So it was transplanted in Kenya in 1938 before the amendment in 1958 and 1964. So the 1965 Act repealed and consolidated all the three legislations. So the current hire purchase law was transplanted from England. The current one that we are using in Kenya was a transplant of the product of that from England. So the Kenyan Act, so this Hire Purchase Act was brought before the Parliament of Kenya, and the parliamentarians then gave their own view about this hire purchase law. So according to Martin Shikuku, he says that this hire purchase law is not a law for the rich people. It's not a law for the law for the poor. It's not a law for the poor, but it's a law for the middle class and the rich people, because it takes himself as a person who speaks for the poor, and he says that according to Martin Shikuku, it should not be called the middle class or higher class charter. It should be called the middle class or the higher class charter. I am the president of the poor, and poor men don't even buy bicycles, so they don't go in car they don't go in for cars on hire purchase. Is therefore to benefit those who are able to buy things, but not for the benefit of the poor. So Martin Shikoku rejects that notion that hire purchase agreements are agreements mainly for the poor, because the poor cannot afford to buy vehicles or bicycle, even a bicycle on hire purchase. So this is not an agreement that is being brought for the poor, but it's an agreement for the middle class and the high class. So according to J.M. Kariuki, another parliamentarian, also says that he's the sponsor of the bill, and according to J.M. Kariuki, he even stated that he has bus owners in mind when preparing a bill. So taking about the financial ceiling initially fixed at 4,000, so it takes in mind the bus owners. So the reason why though not leave it at 5,000 is because most of our people who are taking goods on hire purchase are bus owners, and most of them, buses in this country cost between 3,000 pounds and 4,000 pounds. So J.M. Kariuki defends the bus owners because he's a bus owner. So according to Honorable Masinde Muliro, another parliamentarian, legislation should be primarily interested in the majority of the people, not a few, and not a few handful and scrupulous businessmen who would like to rob everything and make themselves rich, despite the fact that their acts bring misery to millions of Africans in the country. So according to Honorable Masinde Muliro, he says that this hire purchase agreement should benefit the majority, not a few unscrupulous businessmen who just take in their interest and they don't care about the few minority Africans. So it should be based on the majority interest, according to Honorable Masinde Muliro. So hire purchase agreement looked at the definition of what hire purchase is. So the elements of bailment and hire purchase and the elements of option to buy. So the elements of bailment of hire purchase and the elements of option to buy. The case of Helbis versus Matthew in 1895, this is the case classicals in hire purchase. And the owner of a piano, this is the case that involved an owner of a piano who took this piano on hire purchase and agreed to pay them on installments. So he was supposed to pay 136 monthly installment, but he did not complete all the installments, and he went further to offer this piano as a security to a third party, though he didn't even pay that third party. So this is the case. The owner of a piano agreed to let it on hire purchase terms, that the hirer, man called Brewster, will pay it by 36 monthly installments. So the agreement permitted the hirer to terminate the hiring by delivering upon the piano to the owner. So the hirer remaining liable for all arrears of hire. The agreement provided that if the hirer punctually pays all the monthly installment, the piano will become his sole and absolute property, and that until such full payment. So the piano will continue to be the sole property of the owner before the full payment of the installment. So the hirer received the piano and paid a few installments and pledged it to a poor broker called Matthew as a security for advance, to hold it for advance. So the court at no point did the court said that at no point did the property pass from the owner to the buyer until all the 6 installments, because the 6 installments were not paid. So the property did not pass to the hirer from the owner, because all the 6 installments were not paid, because this person Brewster only paid some of the installments, but not all of the installments, not 2/3 of the installments. So not all the installments were paid to the owner of this piano. So these elements that were brought out from this case of Helbis versus Matthew are as follows. First of all, it's a contract of hire. Hire purchase is a contract of hire. So the second element, there is an option to purchase. There's an option to purchase. And when you offer something on hire purchase, that means that you're giving an option to purchase. The hirer has those options to purchase, and in this case Brewster had options to purchase that piano, and it's a contract of hire. The third element is that a contract of hiring which could be terminated at the will of the hirer, who had the option to purchase the goods by making full payments. So when you make full payments, then you have that option of terminating that contract of hire, or that contract of hire purchase. So if Brewster could pay all the monthly installments, that means he could have terminated that contract of hire. So the fourth element is that parties are owners of goods. Parties are owners of goods and the hirer. So the two parties. This involves Brewster and that one who owned the goods. So there are two parties, the owner of goods and the hirer, who are involved, according to the case of Elvis versus Martin, the case classicals on hire purchase. So let us look at the agreements that are regulated by the Hire Purchase Act. So this act regulates some agreements that it cannot qualify as an agreement for hire purchase. That those agreements that are regulated by the act. So the agreements where hire purchase does not exist, 4 million. So this act applies to agreements where hire purchase does not exceed 4 million. So hire purchase does not apply to the agreements that exceed 4 million. So if it's an agreement that is above 4 million, then it will not apply under hire purchase. And this is just a notion that tries to exclude the rich, because the rich are those people who can transact this particular agreement. So if you say that the agreements should not exceed 4 million, that means that the rich are excluded, are discriminated from these hire purchase agreements. So that is it's just a restriction on hire purchase. So let's look at the consequences of non-registry. What if this hire purchase agreement is not registered? And this was held in the case of Fidelity Commercial Bank versus AgriTools Limited and 3 others, 2004 EKLR. That where an agreement is not registered, the owner has no right to recover that piece of property. In this case, it was held that an owner has no right to recover a motor vehicle from the hirer where an agreement had not been registered. So hire purchase agreements must be registered and they must be in written. The hire purchase agreements must be written and must be registered. So the agreement cannot be entered or enforced against the hirer or the guarantor. The owner will not be allowed to recover the goods from the hirer. So the security given by the hirer by the guarantor is not enforceable against the hirer or the guarantor. So the hire purchase agreements must be registered and they must be in written form. So the termination of agreements are provided for under Section 12 of the Hire Purchase Act. Either party is free to terminate the contract. The hirer and the owner, both of them are free. So the parties here, the hirer and the owner, are free to terminate that contract. And the hirer has the right to terminate the agreement anytime before the final installment is paid. So you can terminate if you are the hirer at any time that you feel you are not able to pay the final installments. The hirer must give a notice in writing to the owner before terminating. So don't just terminate, you must give a notice to the owner of these goods that you intend to terminate that particular hire purchase agreement. So the hirer, according to Section 12, subsection 2 of the Hire Purchase Act, the hirer will be liable in damages if he fails to take reasonable care of the goods. So if you are the hirer, you don't take reasonable care of goods and these goods get spoiled, and you will be liable under Section 12, subsection 2 of the Hire Purchase Act. So where he terminates the contract, he must return the goods at his own expenses. So you'll be liable for the expenses to returning the goods, and if you have tampered with the goods, you'll pay for that act of tampering with the goods as the hirer. So Section 15, subsection 1, the owner shall not enforce any right to recover possession of goods where 2/3 has been paid. So according to Section 15, subsection 1, where the hirer has paid 2/3 of the installments, then you cannot, you have no right as a owner of the goods to terminate that agreement or to recover the possession of goods. So you just need to be patient until all the installments have been paid. You don't have that right to repossess, to recover possession of goods when the hirer has paid 2/3 of the agreement. So we have rights and duties of both the hirer and the owner. So the duties of the hirer is to take the duties of the hirer is to take the delivery of goods. Take the delivery of goods if you are being given by the duty of the hirer is to take the delivery of goods from the owner, to receive reasonable care of the goods, to give reasonable goods in his possession, must keep these goods well, and not remove or permit removal of the goods from the premises where they are normally kept or from Kenya without the consent of the owner. So you just go and take that goods from the premise where the owner has kept it without his permission, or to another country is not allowed as the hirer. You don't have that permission to take it outside the country before paying all the installments, according to section 9 and 10 of the Hire Purchase Act. So you're not permitted to transfer the goods before getting permission from the owner. So you also have that duty to pay all this, to pay the installments when it is due. You must pay the installments and continue hiring the goods for the agreed time, and not to let or sell part with the possession, or sell or part with the possession. So you're not supposed to sell that goods or part with the possession before you pay all the installments, and you must pay them for an agreed time. So let us look at the remedies of the owner. The owner can terminate the agreement and repossess the goods. After repossession, the hirer may still redeem the goods within 28 days by paying the balance due together with reasonable costs incurred by the owner in repossessing and any other costs. Can also sue for damages. If the hirer has damaged the goods, can sue him for damages, and you can be compensated for that if the hirer did not pay all the installments and he tampered with the goods. And where the owner is in breach of warranties and conditions, the hirer may sue for damages for breach of conditions and warranties. So if the owner breaches the warranties and conditions, they can also be sued. So the difference between hire purchase and bailment is that bailment, there is option to purchase. There's no option to purchase under bailment, but in hire purchase you have that option to purchase. So under bailment is just agreement for bailment of goods, where the goods will be transferred from the bailee to the bailor, from the bailor to the bailee temporarily. The bailee just holds these goods temporarily. But under hire purchase, there's that option to purchase these goods. After the hirer has that option to purchase the goods after paying all the installments. And the difference between sale of goods and hire purchase is that hire purchase, money is paid in installments, whereas sale of goods, there's no installments. So we've looked at the hire purchase, the law on hire purchase. We've looked at the case classicals of Helbis versus Matthews. And we also looked at the elements of hire purchase that were brought out from the case of Helbis versus Matthews, the definition of hire purchase, the act of hire purchase in Kenya before the Parliament of Kenya, and how these parliamentarians viewed and their own opinion concerning the act. Some were viewing that this was just an act for the rich, but some also claim that it's not just an act for the rich, it's also an act to benefit the poor as well. So that is all you need. That is all about this hire purchase law. And have a nice day, and subscribe to Scott's Legal channel.